The actuarial profession is especially well placed to support regulators in safeguarding the interest of policyholders. This is partly because the profession's training and practice provides insight and experience in managing the risks which insurance companies face. It is also because the requirement to serve the public is highlighted in the principles of the profession. Lastly, this is because profession's training and practices provides insights and experience in managing the risks which insurance companies face. Supervisory structure can also assist non-actuarial supervisors to understand better what is going on in an insurance company, can help in the formulation of sensible and practical regulatory requirements, can help to devise solutions to problems which best protect the interests and reasonable expectations of policyholders, and can act as an effective communication bridge between the supervisory authority and the actuarial profession. The source of laws. For actuaries, it is important to be familiar with legal requirements that impact on their work. In order to grasp the detail of any regulation, interpret it soundly, and understand the implications for actuarial work, it is important to understand the source and context of the regulation. In any jurisdiction, laws and customs exist for the good order of the society. In general terms, the source of authority is provided for in the Constitution or other fundamental documents of the jurisdiction. The way in which the broad structure of lawmaking is conducted in most countries falls to one of two main traditions. These are the common law system and the civil code system. The difference between common law system and civil code system. Common law system evolved in England over many centuries, and influenced the legal structures of countries with an English heritage, including the US and Commonwealth countries such as Australia, Canada, South Africa, and India. Civil code system originated in ancient Rome. The ancient Roman structure formed the basis for the French system, which Napoleon introduced into much of continental Europe. From there spread to other regions such as Latin America. Systems of law based on a civil code also referred to as being based on Roman law or the Napoleonic Code. Official roles of actuaries. The actuary usually has a role in the regime for prudential supervision. The official role of the actuary is related to the financial condition of the entity under supervision. Actuaries may have other roles in these entities, but these may not be a requirement of the supervisory or regulatory structure. Actuaries who have a statutory role and other commercial roles must ensure that commercial considerations do not influence their statutory duties. In defining the official role of the actuary, legislation or regulations often define who can be an official actuary, what the official actuary is required to do, what obligations the official actuary has to report to the company and to the supervisor, what topics and areas the official actuary has responsibility to cover in these reports, whether the official actuary has powers to obtain information needed for the task, powers to obtain access to the people to whom they have a responsibility to report, and protection from their efforts being frustrated. Practical implications for actuaries. Legislation can impact implicitly on the nature of the risks that actuaries are estimating or assessing, or explicitly on the advice itself. Actuaries should be aware of the professional and legal obligations attached to their work. If they are giving advice required under laws or regulations, they should be familiar with the requirements and also any professional standards of practice. Actuaries are rarely qualified lawyers. There may be times when an actuary has to seek advice from and collaborate with lawyers to ensure that his or her work reflects the legal situation and to consider any trends that may have implications for his or her work. When an actuary takes on an official role, just as with all roles, the actuary should only act if he or she has the capability to fulfill the obligations of that role. These information can be referred on the book and internet as shown. That's all from me, thank you.